too.
My Lord,
Okay, let's
I don't
continue.
doubt what the court is, but I'll verify.
Yeah, it's
it.
not.
Thank you. Let's move now to after 2:30.
Aro lebella camera first two.
We go to page 8.
How do you go page 8?
Serial number?
Can I have the serial number?
I think it's 532. It's 532.
Yes.
532.
Do you see that?
Okay.
Yes, I can see it.
What time was it booked out?
But lunch we're gonna go, man.
Why the suspect charged, not back?
Eh?
Sorry?
532 means it is 235 suspect charged.
532 says the suspect was charged.
Within 2 hours after you brought him back at 2:30.
Camera 2 hours after Mushedi.
It's only 5 minutes.
No, it's only 5 minutes.
Is that not 0450?
If you will like a serial number 531, that you need 2619.
531.
Sorry?
So 532 is 0450.
0235. Suspect charged. 532.
Okay, in 5 minutes, after 5 minutes you charge him.
Yes.
So the following day you took him to, he was transferred to Fosloras.
Camera Jajlela to Lela Misha for Sloras.
Hello, Isali Chachileti Mara Fapa Nagat Hour, 10 to 5.
No, it is still the same day, just a difference in our time because we took him out.
10 to 5.
We took him out at 10 to 5 on the 19th of June. So we long a lot over. We should any card in Joma some keeper with 10 to 5.
To Fosloras court.
The very Misha for Sloras.
When you booked him out, under which cast number?
The Beli Munchaka cast number
160 of 10, 2018.
163 of 10 of 2018. Some keep on getting later 163 of 10 of 2018.
So that means he was transferred to a wrong court.
Go to where for a senior.
Check our Nagola to check in that evaluate. The Salushija or a killer phone like uGininda for refit Morocco police station.
Like I said, when I was asked questions by Mr. Baloy, I explained that we were called by the Brigadier uGininda, informing us that we needed to go to Morocco.
I understand that. My question is, when you booked him out to be transferred to Fosloras court under cast number 163 of 10, 2018, you were transferring this accused person to a wrong court. Answer the question, answer is it yes or no?
No, I think I only get a person that Halimanchaka case number 163 of 10 of 2018. Imisha wa ya Foslora. Ibesi ga khezi e linyo. Where horong a senior.
Asinit.
No, that is not true. Because he went to court on that day. Yeah, but I'm only going so long about why I ain't got no long.
All right. Can you please give me the cast number where accused was charged with possession of drugs?
Before what?
Possession of drugs.
Kupa urboche nomoro ya khezimo mlato fajiling abe mlato validi dibash.
This case number 278 of 6, 2020.
278 of 6.
No, sorry. 534 of 6, 2020.
The case number is 534 of 6 of 2020. It's the number of 534 of 6 of 2020.
So was he charged under the cast number?
Wele abiyamla tu kas mo kezingi. I remember that was the case.
So you are not
Mbona
sure?
ukuthi kwenza kanjani?
You are not sure?
Alina Nitia.
I don't know Chachi.
Sorry?
I don't know Chachi.
Let me say he was charged. What was it?
All right. The SAP 14 capital letter A notice of right in terms of that docket 534/06/2020.
No, we'll have to check that when the docket comes. I know this is a specific in the docket.
So are you referring to this matter which was ultimately not placed on the court roll of first lawyers?
That is correct.
Yes.
Yeah,
All right. Now we'll pause on the basis of the call that you received from Brigadier uGininda and instructed to go to Moroka police station.
I'm more learning which Mulaja Ojang ka phone out of hope Brigadier uGininda already Yenko Moroka police station.
In the Yoga Opola Napola Carltonville, statements are necessary. After a lower our court, will Adumela or no? I would have Adumela Brigadier or what they were saying. Nakamana to Apla. That is why I refit Lamaro. Here, after ritual, Carltonville mining, after our field statement.
After we came from the mine in Culturalville where we received the statements,
Wila which are Brigadier Danjula, which are Brigadier, now would save us in Ngasi detail.
the brigadier said, Mr. Ndanzi said to the brigadier that he has some information about the death of Senzo Meyiwa, but I'm not going to go deep into that. Umsola uthi Watshela ubrigadier ukuthi kukhona ulwazi analo mayelana nokubulawa kaSenzo Meyiwa kodwa ngifuna ukugxila kuloko.
Sir, when you were asked, after you verified the whereabouts of accused number on the 26th, all right, let me just put it this way. Were you present personally when accused number 2 was discussing such with Brigadier uGininda to say he has a knowledge?
Wena ge mlato batho bolela le Brigadier uGininda are ona le tsebo ka areng o buletše Brigadier uGininda wena o bola gona wa ikwela ka tsaba tša gago ge a bolela le Brigadier uGininda ka tseo. Yes, I was present. Yebo ngangikhona umsola etshela Brigadier uGininda uthi unolwazi mayelana nokushona kaSenzo Meyiwa.
There's a question that was asked, the reason why I'm saying this, and the reason why I'm going to argue for the rejection of that statement. There's a question that was asked from one of the officers as to how did accused number 2 related to Brigadier uGininda as to in terms of making a confession. How did he reach him? Now we are bringing the answer in terms of that statement you made on the 25th of October.
Vele utisha statement about mkhobulishe nga 25 cha October gore mlato fatsha o ela molala yang Brigadier uGininda gore una letseyo.
The reason, sorry.
I'm sorry, my Lord, the court pleases. I don't know to which officers my learned friend is referring to, but the evidence of Sergeant Mokhan is clear that it was only him and Brigadier uGininda, Sergeant Mohola, and Mabena during the location.
Yeah, sir.
My Lord, I'll refer back to the questions that I've asked from Mapumulo or Jonathan, Sergeant Jonathan, Constable Jonathan.
Jonathan knows nothing. That's his evidence. He was just an escort. He had nothing.
The question, my Lord, he denied, I understand.
Yeah,
he was not going to accept. But the only question I asked, the practical part of the question was whether, how did accused number 1, as he got instruction from uGininda to take accused number 1 to Rapado, how did accused number 2 communicated with Brigadier uGininda? There was no answer from him. He could not answer that because he was not part of the conversation.
There was no answer from him.
Now I want to explain the reason why I raise an objection on that statement is because a statement was made after I've asked that question from Jonathan. He's now bringing the answer from the question I've asked from Jonathan. May I just put it this way? Let me put it this way.
I think President,
At the courtroom, accused number 2 denied his involvement.
Yes.
That is correct.
You went to his workplace. You were satisfied with the statement given by the HR manager.
I'm saying that in his denial, he said that he wants to take us to his work where they're going to confirm where he was on that day.
Yes, I'm covered with that part. My concern was that accused number 2, before uGininda drove with Sergeant Mohola, this is his instruction that you and Mabena, after you had a discussion with Brigadier uGininda, you asked accused number 2, you in person, you asked accused number 2 the direction back to Rustenburg because you wanted to take him back to the place where you arrested him.
Brigadier uGininda to sipila le Sergeant Mohola. Wena ka wena wela butsha molato fatsha obubidi gore tsela ya go ya Rustenburg e sipila bya ka gore le belinya go boela kwa.
Is it not the opposite, Mr. Ngomezi?
My Lord?
Is it not the opposite, that accused number 2 was the only person who knew where he works, namely Sebanye Mine?
That's correct.
He didn't know with his brothers Mabena.
That's correct.
And according to how I understood the evidence, he, number 2, is the one who was showing them Jegalapa, Rulalapa.
Correct.
Right up to the mine.
Yes.
Right. But you see, wait. He is the one who, with Mabena or Mahoni, who went to Bokeng police station. Now you are putting it to him that number 2 showed them how to get to Rustenburg. Are you with me?
I'm with you, my Lord.
Yes.
May I just clarify that?
That's it, yeah.
According to the instructions of accused number 2,
Right.
after uGininda, Mohane, and Mabena were satisfied that he was not at the workplace,
Right.
that's when they decided to take him back. Actually, that was the time when they decided to release him. That means to the satisfaction of what they got from the human resource manager, to release accused number 2 on the benefit of the information that was given to them. That's when this witness asked accused number 2 to take him back to Rustenburg. They wanted to release him.
I see, okay. You can.
That's my version.
Can you please repeat the version, sir?
All right.
Bit by bit.
Bit by bit. Accused number 2, Firstly. he denied from the bedroom in the killing of Senzo Meyiwa. He denied that.
Hana ho bolaya Senzo Meyiwa.
And there was no follow-up after that denial, except... May I proceed?
Ha hona se sileng sa diwa ka morago ga gore a bolele bjao ka ntle ka gore
The time, except when he was asked as to where was he on the 26th of October. He answered by saying he was at the workplace.
ka ntle ka gore o pele ba mmošiša gore ba le kae ka di-26 yena a re o ba le mošomong.
Then the following day, you took him to the workplace in Carltonville, not in Westonia.
Ka letšatši le latelang le le la mo tšea la mo iša mošomong.
You made your own investigations
Le le la dira dinyakišišo tša lena fao
until you were finished with the statement by the human resource manager.
go fitlhelela le fetša ka statement sa human resource manager.
After that, you convened a meeting amongst yourself,
Ka morago moo le le la ba le meeting wa bolena.
Ugininda, Mohola, yourself, and Mabela.
Le be le uGininda, Mohola, wena le Mabela.
According to his instruction, there was no discussion between uGininda and accused number 2 in relation to the admission of any particular information relating to the death of Senzo Meyiwa.
Molaofatša re yena ga ona nako a nka ba a bolela ka ena ka gore o na le tsebo ya go ka lehu la Senzo Meyiwa.
After uGininda and Mohola departed,
Ka morago gore uGininda le Mogola ba sepele,
you then asked accused number 2
ba re wena o ile wa bošiša molaofatša wa bobedi
the direction back to Rustenburg.
gore a le bontšhe tsela ya go boela ko Rustenburg.
To him, he was under the impression that you were satisfied with the explanation and you were going to release him.
Ka mokgwa ba bolelang ka gona, ka mokgwa ba nagana ka gona, o re wena ena o ba nagana gore le kgotsofetše ka se a ileng a le hlalosetša sona, ebile le be le nyaka go mmušetša gae le ile molokolola.
Ntate Mogomeso, ke kgopela gore client ya gago e go botše nnete a se ka bolela maaka ka gore
I'd like to ask that your client tell you the truth. He mustn't lie to you.
ge re tšwa ka jareteng ya mine
When we left the yard of the mine,
šetše re kry le bohlatse bja gore ba se go mmerekong
we already had the evidence that he was not at work.
re phakile ka ntle ga mine mo gating.
We parked outside the premises of the mine at the gate.
Then a botša Brigadier uGininda gore o rile kgopela bolela Brigadier uGininda ka re na le mo koloing ka re no a tle mo koloing ya rena ka re ba sepenana le Mabela.
Well, he asked to speak to Brigadier uGininda, and they had to come into our car because we're with Mabena.
So a tla Brigadier uGininda mo tšho na bothata ke eng entrance.
When he arrived, Brigadier uGininda asked him what was the problem.
A re bjale ka gore mo mošomo wa ka ba ntatola be ke seo.
And he said, well, since my work confirms that I was not at work,
Kgopela go botša nnete.
can I please tell you the truth?
Gomme Brigadier uGininda o ile a mmiletša ditokelo tša gage
Then the
gape.
Brigadier uGininda read him his rights again.
So re tlo se bolelago e be le gore ke nnete fela, and then ya fe a mmotša, and then a tšwela pele a bolela ganyane. Brigadier uGininda a mo emiša
Well, Brigadier then told him that what he's going to say must be the truth, the whole truth, and nothing but the truth. And then he started talking, but uGininda stopped him as he said, stop right there.
gomme a mmotša gore no tše dintšhi ka gore nna ke nna mophenyi ke tla nyaka officer e neutral.
Well, he said, going further, since I am the investigating officer in this case, I will need that this be performed by somebody that is neutral.
in a form of confession, we will like a Zulu confession. We will
And then he spoke about the confession, but I don't know how to put that in Zulu. Even I understood, because I understand Zulu a little bit. And then when we parted, he said, Mr. Ndanzi, are you satisfied? And Mr. Ndanzi confirmed that he was satisfied. If it were possible, I would get Sergeant Mabena to rise again and come and explain and be my witness here, because what Mr. Ndanzi is saying is not true. When we parted, the brigadier said, I'm going to look for a person who's going to take the confession. And then he would phone me. And then they explained to him that is Mr. Ndanzi, and he agreed.
Okay. Sir, according to the booking of 2:30 when he was booked in at Pretoria North, there was an entry that he was supposed to be transferred to Vosloorus. If accused number 2 intended to make a confession, was it necessary to transfer him to Vosloorus court?
Hello, Ramlatfato, where Nyagobolela, Nito, Amagala Mlatu, Ubasancha issue go Vosloorus court.
Entering with your suspect charged to court.
Can you please answer my question?
No, I want to explain it to you. I want to explain it step by step so that you can understand me.
Suspect charged, what are you looking at Pretoria North?
When it says suspect charged, he is then taken out of the books of Pretoria North.
That is when Brigadier uGininda afuna lukikele moto awujala confession fitang Morocco.
That is when Sergeant uGininda called and said, I found a person who can take the confession. Please go via Morocco.
Sir, my question is now, amongst or in all the exhibits where you relate the movement of accused number 2, is there any entry where you specifically mentioned that accused number 2 is booked in and out under case number 636 of 10/2014? Is there, and I'll give you a chance to go through your exhibits, is there any recording under case number 636 of 10/2014?
No, there is nothing like that.
Police station. Ginda called, I think really rapaju for before Liapa. Live with them Morocco. Morocco don't have a roots any for confession.
Well,
Pretoria North.
When we left Pretoria North,
Brigadier Ginda ufoni lor like ikele moto mara before they court fitang Morocco.
Brigadier uGininda called and said he has found someone. So, but before you go there, go via Morocco.
Thank you. Yes. I'm still with my question. When, according to your evidence, when accused number 2 was taken to Morocco police station for a confession, for the taking of a confession, there was no entry to say he is booked in at this time under this reference or reference number under case number 636 of 10/2014 for a confession. There's no such.
re tla tšea molatofatšwa le meiša ko moroka le re o amogela molato a ona mo o ngwadilweng gore molatofatšwa o tšerwe a nšiwa ka case A ya 636 of 10/2014 a ona mo o ngwadilweng
le bolela ka kwa moroka
are you talking about it Miroka?
Correct.
alright eo e tla tla tlhaloswa ke brigadier Gininda
No, that will be explained by Brigadier Ugininda.
tla tlhaloswa gore yena le Colonel Raphadio ba arrangitše bjang
He then explain how they arranged with Colonel Raphadio.
Okay, please forget about Brigadier Ugininda now and Raphadio.
Ke kopa o re bale ganyane ka Brigadier Ugininda le Raphadio.
They did not bring accused number 2 to Moroka Police
A se
Station.
bona ba tlišitšeng molatofatšwa o pedi ko Moroka Police Station.
I'm referring to a recording that was supposed to be made on the occurrence book that accused number 2 was booked in under CAS 636 of 10/2014. There's no such, unless you prove me wrong.
Na ke nyaka no o no mpotša gore se ke se bolelang sa gore molatofatšwa ga a ngwalwa tlase ga case ya 636 of 10/2014 ke nyaka fela o no mpotša gore no ga o bjalo and o mpontšhe mo dibukeng gore o ngwetšo kae.
ke a dumela gore a ngwadiwa
I do accept that he wasn't recorded.
Every time, according to these exhibits and the records, if they are not referring to a court appearance, they simply say booked out for investigation, booked in for investigation, after investigation.
Ka ntle ga gore o išitše koto mo ga ona ba ngwala fela gore ba mošitše ba ilo dia dinyakišišo ba mošitše ka morago gore ba die dinyakišišo.
a ke gane ka boko o tlhalotšang gona ke re go ya ka officer e tšeang confession gore e nyaka motho ona a tle bjang so I was not instructed gore ke mo fetiše lesele ene Moroka is not my place if ba na boletše Colonel Raphadio gore mogate ntlišetšana gare ga disele ne ke tla motsentšha ka mongwadiša ka motlogela mo.
No, it's usually according to what the person who wants to take the confession instructs. Because, I mean, if he had told me that I should take him to the cells, I would have taken him to the cells.
There's nothing that prevented Jonathan at Moroka Police Station from making such an entry, because he's the one who took, according to your evidence, he's the one who took accused number 2 to Colonel Raphadio, not you.
Hona ntho e be ka palla Constable Jonathan gore a ngwale gore o motsenšiše mo because a kere ka mo go wena o boletšeng ke yena mo tšereng a miša ko Colonel Raphadio.
nka fetola so Jonathan o kgopetše ke nna.
Well, I can answer it this way. Jonathan was requested by me
because be ile motho gore a tsebe selo ka molato
because he was not involved and knew nothing about this case.
ene ke sa bole jaaka pekere Brigadier Gininda le Colonel Raphadio a jaaka ba mpa instruction gore motsentše lesele ba le gore mo tliše mo keleng.
Well, I want to reiterate that Brigadier Ugininda and Colonel Raphadio never gave me instruction to take him to the cell. All they said to me was, bring him where I am.
I've got the standing orders of the IO, of the colonel who's taking a confession. I'll come to that, to relevant people. But my concern, let's just be honest and frank to the court to say there is no recording under 636 of 10. Then we'll move on.
I don't know, kwana ka gore a ona mo ngwadilweng ka 636 of 10 re tšwele pele.
ya dumela sa go botsa ga go na le lebaka le lore Brigadier Gininda come in a o tla tla mmotšiša gore o tlile bjang gore a fe instruction ye so.
Well, I do accept, but then there is a reason, and you should bring Brigadier Ugininda to come here and explain why it happened this way.
All right. I'm not yet done with my, but I just want to draw your attention on the day in which accused number 2 was formally charged under CAS number 66 of 10/2014.
But I go to church mo mlato fa joining a bua mlato semmušo wa 66 of 10/2014 ufuna ukuphindisela kuleli langa mhlazane umsolwa esethoswa icala ngomthetho kuleli cala 66 of 10/2014.
He was charged on the 26th of October 2020.
Welabe amlato ka 26 October 2020.
How is that possible?
My Lord,
He was charged on the day he died. The deceased died.
I mean 2020, my Lord. I said
Oh, I
2020.
see. Okay, fine.
Yeah.
Okay. 2020.
2020.
Okay, yeah.
I mean 6 years old. How many years? 15, 16, 17, 18, 19. 6 years.
And
He was
so
charged after 6 years.
A6.
Do you know who charged him?
Wase kumangele muthatha.
Rafo ihlalusha ka bankwishish.
Do
Can
you
you please
know
explain
who
it?
charged accused number 2 under case number 636 of 10/2014?
Wase re kumangele chacha mlato fatwa ka kgetsi a 636 of 10 of 2014.
Ngabucha rona ka tšatši le fe?
Can I just ask on which day?
I said on the 26th of October 2020.
Ka di 26 October
That's the
2020.
day he was charged, formally charged.
Ka tšatši le a ileng a bešwa be mlato semmušo.
Ke nna.
I was the one who did it. Yebo imina ngamthwesa icala
On the day.
ka tšatši leo.
Skaro wa Valeria ke nna.
Yes, ule ka eng kwa Valeria?
Va Valeria police station.
Yes, he was at Valeria police station, so I was the one who charged him.
So the following day appeared in court.
Ka
The
tšatši le
27th.
latelang o ile a tlhaga ko kgorong.
Ke nnete.
That is correct.
May I approach case number 2, my lord?
Phambi
Yes.
kwenkantolo ngalelo langa.
Yes.
Accused number 2, my lord, wanted to confirm the date in which the witness charged him on the 26th of October 2020.
Mo la tofatša ba nyako gore a hwetše bonnete ba gore lelela motšhatša ka di 26 tša October 2020.
Ke nnete ka gore ke nna be ke le in charge ya gore ke mo phenyi ke mo tlhokomele ebile.
Well, that is true because I was the one who was in charge of the investigation and to look after him on that day. Yebo kwakuyimina ngoba kwakuyimina wafanele enze uphenyo futhi ke kube yimina omgcinayo ngalelo.
So 48 hours lapsed.
So 48 hours ile yafika.
According to the rights to be charged within 48 hours and to be brought to court on the next available court day.
Gore 48 hours ya gore a chargiwe ile yafika le judge la gore a ishwe kgorong.
Le bolela ka molato ofeng?
Which case are you referring to?
Because
I'm sorry, my friend.
Because I do not
Was-
understand which case you are referring to.
The answer you were giving, for which question were you answering?
Araba Pushif.
Or ego Wichisha or Korokanya or Abe, I grow with each other. And for case 636. Now we change that we look at the phone. I don't know for 8 hours expired. The lapse gave him one.
I don't understand which 48 hours you're talking about. It is like elapsed because if you are talking about case number 636 of 10 of 2014, he went to the court the following day.
For the benefit of your information, let me just give you this information. When a person is arrested, you understand, under Section 40 of the Criminal Procedure Act,
Section 40 of the Criminal Procedure Act,
with or without a warrant, must be charged within 48 hours according to the Constitution.
Do you
understand that?
Yes, I do understand.
He was not arrested on the 26th of October 2020.
26th October 2020.
Do you understand?
That is correct.
But instead he was arrested on the 16th of June 2020. Do you understand that?
16th June 2020.
So 48 hours lapsed years after that. Do you understand?
48 hours elapsed.
Oh, months, sorry. Months.
Do
you understand?
Let me answer you in this fashion. When we arrested in Dancy, it was not for the matter of Senzo Meyiwa. If you can look at the indictments, I don't believe they are far behind. They were around those days. There were cases, when we did charge him eventually about this case of Senzo Meyiwa, there were other cases that he had been charged with before.
Maybe you misunderstood the provisions of the Act. He must be charged within 48 hours according to the Act.
If one are feeling SAP 14A, Yawara was Malato says we were case for 636 of 10/2014. Negative email elapsed 48 hours. Well, SAP 14A, 636 of 636 of 10/2014. That's about a motto. Get it out with your chemophilia on
if you can look at the docket, you'll be able to find out when I gave him the SAP as 14A regarding the case of 66 of 10/2014 of Senzo Meyiwa.
Sir, we cannot play. Okay, let me just go.
Sorry, Mr. Gomezuru. Just it's a question of law.
Yes.
According to this witness, the arrests, if I must term it that way, of Mr. Senzo, Mr. Ndanzi,
yes, my lord,
went in sequence to what he was eventually charged with.
Yes.
So he says necessarily when he was charging Mr. accused number 2, it didn't follow that the charge related to his arrest on the 16th. Am I understanding correct, sir? Because there were other contemporaneous charges which were being preferred to Mr. Ntesi. For instance, the Pukeng case of allegedly drugs, the Pukeng case of allegedly the 13 rifle bullets. In other words, sometimes, and I'm just saying as I understand the law, sometimes it happens that you charge a person today, for instance, and then he doesn't appear in court within 48 hours because there's an intervening sequence of another arrest. He can tell you, he was a prosecutor, where the investigating officer actually withdraws the charge and then he just puts a hand on you, as you know, Mr. Nisi, puts a hand on you and charges you with another offense. Are you
Yes,
with me?
I'm
You've
with
never
you.
experienced such a sequence.
My Lord,
Okay,
I have
fine. I was just mentioning that.
different. May I just address the court as well in terms of
It's okay.
how I understand the law?
Yeah.
A confession, it's when the accused or the confessor admits all the elements of that particular offense.
Now we're addressing two different things.
Now, my Lord,
I'm addressing the arrest and the charging, not...
may I be given a chance to explain? Because if a confession was taken on the 19th of June 2020, the state or the police at that time or the investigating officer had sufficient evidence to take the matter to court. Had sufficient evidence. Instead, even if there are certain other matters, what should have been done was to take, after the confession has been made and to the satisfaction of how it was complied with Section 217, place the matter on the court roll
Yeah, fine. I
for
agree.
further investigations if they still need further investigation. Then they will add charges as the investigations carry on. That's how I understand the law, my Lord.
Yeah, no, quite.
Thank you.
You know, we just...
The reason why I'm saying he was supposed to be brought to court within 48 hours.
Lebaka le re ke re o ba swetsa she gorong e feta di hour tse 48.
A prima facie case has been established by the state in that a confession has been made.
Re re se sa ka se ke la ba ya ganwa e be itlisitswe mo gorong ka lebaka la gore ne ba mo molao.
But on the 19th, after the confession was taken,
Ka di 19 ka mora gore confession e tšewe
to my surprise,
ntwe maka tšanke
accused is further brought to Vosloorus police station, to Vosloorus court.
o iswa police station asa iso.
Please, my Lord, I think my learned friends putting a wrong proposition to the accused. The position as set out by the court is correct. It doesn't mean that when a confession has been obtained, that person must now appear within 48 hours. It's during the course of the investigation, more evidence is being gathered, and the investigating officer will come and explain as to when was accused taken to when was accused charged and why at that particular time. But the proposition as put by my learned friend is incorrect.
May I reply by saying, my Lord, accused number 2 was not formally charged. On the 19th of June 2020, he made a confession before a kennel. Accused number 2, after a confession has been made, the principle of law in terms of Section 35 of the Constitution 108 of 1996 prescribes that any arrested person, is referring to any arrested person, must be brought before a court of law. Formally, he is arrested because he made a confession on the 19th of June. That's why the state established a prima facie case. He is arrested. The Constitution provides a right that must protect the accused, that he must be brought to court within 48 hours. As per your entry, I'm making submission. As per the entries or the exhibits, there's nothing on the exhibits that records case number 636 of 10/2014 that has been recorded on the occurrence book. Number 2, in the absence of such recordings, a confession, that means my submission is that if that confession was made at the police station, there was going to be an entry. But because the version of the accused person says it was made at Orlando, that is the reason why we don't have that entry, because it was made in an open area. Do you understand it?
Yes, I do understand you.
So,
Can I answer you?
in conclusion, before you go to, I want to emphasize the right that has been infringed of not bringing accused number 2 to court within 48 hours.
Hona le tukelo e leng ya senywa ka hore la to fa kwa high shock court koron iso try fita ya hora tse 48.
As a good place, my lord. We don't want to belabor the point, but we pointed out that the proposition by my learned friend is incorrect. He is correct insofar as his proposition that an arrested person must be brought to court within 48 hours. But Section 35 distinguishes between an arrested person and a detainee, and the witness has clearly said that there's nowhere an entry that said accused was arrested for 636, and that should answer my learned friend.
Mr. Mgomez, is it not maybe proper that you and all the councils address me, subsequently will have to address me on that very exigency, because it appears I understand the law differently from you.
Yes, my lord.
And I don't know, Mr. Baloyi also appears to understand it differently from the both of us. So Mr. Mnisi and Mr. Malo and Mr. Monye, they'll prepare argument on that exigence. A detained person, an arrested person, etc.
Can you state
And whether those rights encapsulated in Section 33F may be terminated. Just showed you an exigency where the
Can you state this
wait, no. I want you to address me. Like I was saying to Mr. Mnisi, where before he appears in court, the charge is withdrawn. After he has made a Section 35F statement, then he's brought to court on another matter. It happens every day in South Africa. A guy is murdered in Joburg. They find the killer in Neisner. Like when this matter was not put on the roll by the prosecutor, saying it's a case of Nongom. Sometimes a prosecutor like Mr. Mnisi will put that matter on the roll of Neisner to transfer the case to Johannesburg. Am I correct, sir? Yes.
But that has never been done.
No, you've heard me.
Yes.
So let's prepare the law, because we have a different conception of the law, that if he hasn't appeared in Nongoma, that's the end of the story, there's an irregularity, etc., etc., etc. It depends on the intention of the prosecutor, like Mr. Baloyi, what he wants to achieve. Okay.
Yes.
So you can prepare argument on that, sir?
Yes.
No problem. And all of you can prepare argument relating to that exigency.
My lord, in relation to the...
Hello? Yeah.
When will you be expected to argue this point?
No. You'll argue this matter after the argument, when you are addressing me on all the aspects relating to a trial within a trial. It pertains to that. Okay.
But my lord...
But you can make your submissions in the meantime. I'm not stopping you.
No, but my lord, I was just asking frankly as to if such an exigence is not argued, and we still...
No, you can put it, you are at liberty
Yes.
to put anything to this witness the way you understand the law. I'm not stopping anybody. I may be wrong,
Yes.
you know, and you are right.
No. What's the time? Can you take a break, my lord?
What time is it?
1 o'clock. It's 1 o'clock, my lord.
1 o'clock.
Yes.
Let me tell you about, and it has nothing to do with this
Yes.
experience, with my cases. When I was still defending guys charged under the Terrorism Act, The Act would say, Section 33 of the Internal Security Act.
Section 28.
Yeah, you're allowed to be held incommunicado for how many days? 3 months or whatever.
Yes.
Yeah, after 3 months, they charge you, these guys. They'll charge you and then bring you to court. And when you get into the box, the investigating officer tells the prosecutor that you're withdrawing the charge against Mr. Mnisi. You have experienced it. And immediately thereafter, when the client is preparing to go down into the cell, the sergeant puts a hand on his right shoulder and says, I'm rearresting you for a certain other charge. And there was nothing you could do. It was lawful. You can argue, but that rearrest was lawful because the other charge on which this guy was arraigned in court has been withdrawn. Okay, 2 o'clock.